Thanks much for joining us today. I'm your host, Andre Wright, with co-host Anne-Marie Giglio. Hey, Anne-Marie.
Hey, Andre. How are you?
Doing well. I'm glad that you're fine. So this is our fourth episode, and we've been getting excellent feedback on the helpful conversations we have been having. In our previous podcast, we mentioned the legal issues surrounding the current pandemic as it relates to organizations. So today, to discuss this a little bit further, we have our special guest, Jefferson Allen from Cohen, Cooper, Estep Allen, LLC. Hi, Jefferson. How are you?
Hello, Andre. Hello, Anne-Marie. How are you?
Glad
I'm
to
doing
have
fine.
you. Thanks for coming.
Doing well. I'm glad that you're fine. So, Jefferson, to start the podcast, tell us about your background and how you started at your practice.
Well, let's see. I graduated from Emory Law School in 1998 and started working initially with a small firm doing construction litigation and a little bit of commercial litigation. Then in 2000, as the legal market started to boom, I joined a national law firm. I had about 800 lawyers and did the big firm law practice for a while. And realized that wasn't the type of practice environment I wanted to have. I like to have a little bit more flexibility in my practice, more of a hands-on relationship with my clients. When I was working for that big national firm, we represented Bank of America and DuPont Chemicals and a lot of national folks that I was the low man on the totem pole as the associate. And so after working for that big national firm, gradually I've moved down in size to smaller firms and joined my current group about 10 years ago now. And my practice is general business and commercial litigation. My partners do other areas of law. We, cover everything from criminal defense work, entertainment, personal injury, family law, and several of our attorneys do business litigation, which is the focus of what I do. Handle a lot of construction disputes, some labor and employment disputes. And the way I try and describe what I do is I'm essentially, everybody knows what a general practitioner physician is. You have your family doctor. You go to them for your first call for a problem. And if you need a specialist, your family doctor makes a referral. I describe myself as kind of a family doctor for individuals and small businesses. If an individual or a small business has any legal question, I can answer probably about 75–80% of them. And if I can't, I can put them in touch with an expert or specialist who can. So that's my law practice in a nutshell.
And that's why we have you on today with that extensive experience. I know you can help us through this time. So Jefferson, how is this current pandemic affecting businesses from your standpoint?
I haven't seen dramatic impact yet. I think through the rest of this year, we're going to see a lot. The most immediate impact is there was essentially a freeze of civil lawsuits and civil litigation. While the courts extended filing deadlines, extended response deadlines for motions, there have been no jury trials for the past 3 months. And that has never happened, to my knowledge, in the court system. I think even when we go back to World War I and World War II, there was nothing that was stopping the civil court system the way it has in our country. And that's going to have a lot of unexpected trickle-down consequences, I think. I mean, there's going to be a huge backlog of cases. So, for example, with electronic filing that all state and federal courts now have, I have still been able to file lawsuits. And over the past 3 months, I've filed 3. I filed one last night, and I'm going to be filing another one tomorrow. But people have not had to answer them. And there's going to end up being this backlog of cases. Another impact, at least for individuals in their legal needs, is I don't know when jury trials are coming back. And the prospect of a jury trial in civil litigation is one of the things that often forces settlements. most people may or may not know, but really about 90%, 90 to 95% of all lawsuits that are filed in state or federal court get settled before there is a trial. And they get settled at a variety of stages, but a lot of them get settled right before there might be a trial. And what typically happens is the judges bring in 20 different cases and they say, okay, we're going to have a trial calendar. And for these 2 weeks, we're going to try these cases. And all of the parties and the lawyers are forced to scramble and get together and really decide, do I really want my trial or do I really want to settle it? And judges use that as a legitimate mechanism to try and encourage people to settle cases. Well, with these backlogs and with there not being jury trials coming up, you're not going to have those trial calendars. You're not going to be able to get cases settled as much, which is going to leave some disputes floundering.
Yeah.
I think also for the next year coming up, there are going to be a lot more claims of people who can't pay their bills, commercial bills, for one reason or another, because businesses are struggling. And then there are going to be the businesses that don't make it through this time. And there will likely be a huge boom in bankruptcy practice. And hopefully everybody listening understands that there are two general types of bankruptcy filings, and it makes a difference in terms of how one moves forward. The bankruptcy that most people are familiar with, a consumer bankruptcy under a Chapter 7, it's called a Chapter 7 liquidation, where basically if you file for bankruptcy, you put together a list of all your debts and a list of all your assets. And most people don't have assets that are available to pay creditors. And you get a discharge from those debts, and the creditors that you've identified can no longer collect on those claims. And then that lasts on your credit and has whatever impacts it may have. But there are two other types of bankruptcies. One is called the Chapter 13 bankruptcy. It's a wage earners plan. And under something like that, if you have a job and you just have more debt that you can pay, but you're making money, like every month, maybe your net between your expenses and your income, you might make $500 a month positive, but you have $10,000 in debt and you'd never get out from that. Under a wage earner's plan, you can basically say, okay, I have $500 a month to put towards this plan, and that money is going to be spread against all of my creditors for that $10,000 for a period of 3, 4, or 5 years. So most of those creditors might get 10 cents on the dollar, 20 cents on the dollar, but they get something. And the person who went through the bankruptcy has tried to do the right thing. They've said, look, I've done as much as I can, and that's what the law is meant to protect. And then the third form is Chapter 11 bankruptcy, which is typically for a business reorganization. And a lot of your listeners are going to start to hear about major companies going through that. JCPenney just filed, J. Crew, Hertz Rental Car is going to file that. Yes. It doesn't mean that these companies are going away. It doesn't mean that they're going out of business. It means that they're using the bankruptcy code as a mechanism to restructure their affairs to help them survive. And as a small example, I'm not involved in that J. Crew one, but I can imagine here are some things that would happen there. J. Crew probably has a lot of commercial retail space that is subject to 5-year leases. They might know that they have to close like 30% of their stores. As it is, they would be on the hook for those commercial leases even if they close. If they go through a bankruptcy period, they get the right to terminate some of those leases that they would not otherwise get the right to do. And they can also talk about bringing in new investors and borrowing money to help them through this period of time, and they have to get permission from their creditors. So Chapter 11 is a more complex mechanism. People really are specialists in how to do that. But Chapter 11 is a way, it's certainly better than a liquidation, because think of all the people who work for Hertz, who work for JCPenney, who work for J. Crew. Many of those people will lose their jobs, but many of them will keep their jobs. And those businesses will hopefully come out again able to buy from suppliers and sell. So I think everybody needs to understand that there will be bankruptcy coming down the line,
Of course.
but not necessarily to be afraid of it. I mean, it's a process.
And Jefferson, you clearly spoke about the bankruptcy and aspects related to that. But what about the impact on employment laws?
Well, by and large, I don't think employment laws have changed or will change in terms of the laws protecting discrimination for race and sex and age discrimination, things like that. Where there may be an impact on laws in the workplace would be some of the provisions of the packages that have been passed on by Congress to allow greater benefits to take unpaid leave if you need to take care of a relative who might have come down with COVID, or if you're unable to work because of lockdown orders. For example, if you have a job and you don't have unpaid leave and you want to go to your job, but the local government has issued a stay-in-place order, some of the statutes were recently revised to provide protection for employees for those, so they shouldn't be fired for their inability to come in and do their job. I think one of the things a lot of people had asked is, well, if I get sick, can I get workman's compensation coverage? And the answer to that probably is no. And I can explain for your listeners who may not be completely familiar. The concept of workman's compensation insurance and workman's compensation is that many years ago they decided people get injured on the job. It just happens. And rather than set up a situation where employees who got injured on the job would have to sue their employers, and their employers would then be defending those lawsuits, and it's very adversarial. Did you slip? Was it defective equipment? Were you lazy on the job? And all of those things. And the person who got injured would be waiting months and months or years to get medical care, to get compensation. The workman's compensation scheme was established to basically say, okay, employers are required to have insurance to pay workman's compensation benefits. And then if you get injured on the job, the injured employee is going to get paid. They can't sue their employer, but they're going to get paid for their medical expenses for the time that they can't work. And it's a much simpler, less adversarial procedure. But that's for injuries typically on the job. If somebody gets exposed to COVID, that is not likely to be considered an injury on the job. That's a sickness that they might have gotten on the job, but it's something they could have gotten riding the bus or the subway. It's something they could have gotten riding the grocery store.
I had this question, it's probably the other side of it, like as we start to open, how are businesses going to be liable for people coming into their establishment and saying that they gotten COVID from being in their space? How is that going to roll out, do you think?
I don't think that's going to end up being a huge problem. Business owners, hopefully, will have business liability insurance.
Right.
And that should provide a layer of defense or protection for you. It's almost as if it was a slip and fall. You know, if somebody comes into your place of business,
That's the question.
I'm trying to think. I'm putting on my hat now as a plaintiff's lawyer. So if I'm a plaintiff's lawyer and I want to try and make a case, if I could establish that you as the business owner had an employee that was COVID positive and you allowed that person to work and I came in contact with them and that's how I got COVID, then maybe there is a claim for negligence against the employer. But it would be a very difficult case to prove, because how often is it that somebody is diagnosed with COVID and is able to go back and figure out exactly where they got it.
Where
They
they got
typically
it. Yeah.
can't
It's
get
impossible, right?
And from the defensive point of view, if somebody made that allegation that, hey, I came into your restaurant and I ate dinner, and 2 weeks later or a week later, I had COVID, as a defense lawyer, I would say, well, where have you been in the 2 weeks since you ate at our restaurant? Unless you immediately went into quarantine after eating at our restaurant, I think it's more likely than not that you picked it up somewhere else. And so I say that not to say that there cannot be legal exposure for a business having customers in, but I think it's not a great risk if the employers are doing everything they can to follow the posted CDC and local guidelines.
That's what I was going to say. I know that I've seen a lot of business owners here on my street, and I've done the same thing. Here's what we're doing, A, B, C, D, E, we're following the guidelines. We're doing this 3 times a day, whatever. Everyone has kind of a standard operating procedure now that's around COVID. So
Right.
is that giving us a layer of protection then as business owners?
That's absolutely giving a layer of protection. Yes, it is. Because it shows that you're taking reasonable steps to provide a safe environment for guests. Now, what business owners who do that do need to understand is it's no good for you to have the best checklist in the world of all the steps that you take to provide a safe environment if you don't actually follow them. If you have a policy that says you will wipe down the equipment 5 times a day and you only wipe it down 1 time a day, it might backfire on you when somebody finds out that it was only wiped down 1 time a day.
Mm-hmm.
For example, in the slip and fall grocery store context, if a grocery store has a policy and a schedule that a manager will walk the floor once an hour to look for spills, and I think many of them do that. I mean, that's a standard program. And then it turns out that that's their policy, and on a particular day that there was a slip, the manager just didn't do it after lunch, and so you have this 3-hour gap. It makes it much easier to argue that there was water there. I mean, you're going to be hurt by the fact that you didn't follow the schedule and the plan. So it is best to have good guidelines. It's best to follow those guidelines.
So on the other side, as an employee, is it possible for an employee to refuse to go to work and have any legal grounds to stand on if they don't feel it's safe?
That has not been determined yet, and it may very well be the answer to that is no. Because if the business is allowed to be open, and unless the employer is taking really reckless actions and not doing things, I would expect the way that would play out is that would be determined to be a voluntary quit or resign. Georgia is a right to work state, but it's also, you can be hired or fired for any non-discriminatory reason. And if somebody refuses to come to work out of a fear of COVID, I don't believe that the law at this point is going to recognize that as an occupational disease or cure that would need special accommodation.
Is that what it's going to take? Does it have to be classified as an occupational disease?
I think it might, because there are laws right now to protect employees in the workplace. The Americans with Disabilities Act can protect a whole variety of ranges where you're required to give reasonable accommodations and say, I can't come in here unless you can give me a reasonable accommodation. And somebody might try to suggest that, I mean, I'm not sure, because this really is a new area and it depends on how creative people might be.
Yeah.
Let me give an example of maybe where it is. You're seeing in some of the meat packing plants that they are putting up plexiglass dividers between the workstations, something that wasn't there before.
Right.
Now, if there is a plant that has said, we don't want to spend the money, we don't want to put up those plexiglass things, and an employee says, hey, I don't feel safe here until you put up those plexiglass things, maybe there's an argument there because there is a reasonable accommodation. There's something that the CDC and state authorities, state health authorities are recommending be done.
And it's becoming more of a standard practice as well.
Yes,
right?
as that comes up. But at least in Georgia is a very employer-friendly state, and people can be terminated from employment for any reason or for no reason at all, unless it falls into one of the discriminatorily, prohibited actions. You can't be fired because of your race. You can't be fired because you're a woman. You can't be fired because of your age. But if the boss just doesn't like you one day, you could be fired. If the boss says we have to lay off half our staff, the boss could go eeny, meeny, miny, mo. It sounds crazy, but that is not illegal. It would be illegal for the boss to say, we're going to lay off everybody who's over 50 and keep everybody who's under 50. But that's
so Jefferson, how about severance? Is this mandatory for laid off employees at this time?
No, it is not. There's no statutory requirement that laid off employees get severance. The way it normally works in practice, and where I counsel employers who are thinking about terminating employees for whatever reason, often if an employee is to be terminated, there are some complaints about performance, but there are also complaints often from the employee about the working conditions. People view things through their own eyes. And so I'm not saying that people are making something up, but people may view they're put upon when they're really not, and who knows. So many employers will offer severance as a way to placate somebody's leaving so that they don't leave on hard feelings. It's often a business decision. I mean, I will recommend that if somebody's saying I need to let somebody go, it is certainly a good business practice to offer 2 weeks severance, but it's not required. And then if it's a more senior person that's been with the company longer, you maybe make a more generous offer. People need to think about that. And conversely, if you've been with a company for a long time and you're being let go, and you have a sense that it's for some reason other than just a neutral letting a whole bunch of employees go, it might be worth speaking with an attorney, because even if there is not an actionable claim for discrimination, there is often value in communicating with an employment law specialist who can get you severance. I mean, people can get a year's worth of severance. People can get 6 months worth of severance, depending on the situation of where they were in the workplace. I don't think for COVID, though, that's going to happen. One of the other legal issues that I think is going to come back into the news is going to be about the unemployment bonus. Bonus isn't the right word. There was a $600 additional benefit that was provided by the federal government.
Yeah.
This is where we're getting into the law and the politics of it and the economics of it, but that's going to continue to be an issue, because whether or not it was the right thing to do, it was done immediately to try to help keep the economy afloat and have people have more money available to spend and pay. So it was a stimulus type thing. But the unintended consequence of it is when you give unemployment, when unemployment benefits are potentially more generous than what people were actually earning in their jobs, and some people in lower wage jobs fell into that case, then they have an incentive to potentially say to stay out and continue to collect unemployment a little bit longer rather than go and get another job. Where that, if you get called back in, like let's say you work at a restaurant and they say we're closed for a month and then they open back up. Well, once that restaurant opens back up and tries to call you back in, if you don't go in there, you're not going to be able to get the unemployment benefit any longer. But if your company had gone out of, if your restaurant did not open up again and you were receiving the unemployment benefits, you might be in a situation where you used to receive X dollars a month as a cook in the restaurant, and on unemployment, you're receiving X dollars plus 600 because of this new thing. You don't have as much incentive to go and find a job in another restaurant right now. And in Congress, they're starting to talk about, okay, what are we going to do? And are we going to stop that? And when are we going to stop that? And
yeah, that's what I wondered, if there was a finite pool of money for that or not. And I guess that's not been determined yet. And it's almost just, well, it could be a self-regulatory system at that point, if there is a deadline or an end date for it.
Yes, and I don't know the answer to whether it's a pool of money. I have a feeling they would just keep, funding it. I don't know when it's scheduled to expire, but that's one of the COVID issues. Another COVID issue this is more into the health insurance and the law, but may become an issue is we don't know what the long-term health consequences of COVID are really going to be.
Yeah.
And
no, you're right.
And it is entirely possible that there are a variety of long-term problems that are associated with it. And we also, at the moment, with the Affordable Care Act, insurance companies cannot refuse to write a policy for you because of pre-existing conditions.
Yeah.
But we don't know if COVID will generate what are pre-existing because not everything is a pre-existing condition. If I happen to have dandruff, that's not a pre-existing condition. Not every medical procedure would count as a pre-existing condition, but we don't know. It is possible that people who have had COVID could be determined to have some sort of medical condition that if health insurance companies could underwrite and exclude people, they might choose to. And that's where there's going to be a legal issue with COVID coming down the line over the next few years, I suspect.
Yeah, there are a lot of, as you correctly mentioned, there are a lot of issues around COVID. But I wanted to ask you though, if someone is listening and they've just been laid off or furloughed, what are the steps they should immediately take?
Well, what they should receive is a separation notice from their employer, which is a notice that's filed with the Georgia Department of Labor. And I also, typically employees were required to check in every week and report on their status in order to get their unemployment benefits. There was a change during what COVID allowed was the furlough program, and that's where there was a difference in the law. Typically, if a company laid you off, your employment was separated. It wasn't anticipated that you were going to come back quickly. And if it was anticipated that you were going to come back quickly, you could not get unemployment. So as an example, assume that auto plants were not governed by union contracts, as many of them are. Well, no, let's talk about the ones in Georgia that by and large are not represented by unions. If the Kia plant in Georgia says we don't need to make as many cars right now, we're going to suspend all of our operations for 2 weeks. We're going to furlough everybody. They would basically say, everybody go home. We're not going to pay you for 2 weeks, but when we call you back, you come back to work. Those people would not be eligible for unemployment because their employment hadn't been separated. What the recent statutes in dealing with this emergency allowed were for those employers that were basically forced to shut down due to the emergency. They were able to furlough their employees, continue to pay health insurance for them, but those employees were then allowed to file for the unemployment insurance claims. That's one of the things that was different about this, and it was, I think, the right policy decision to allow people to do that. But to your question specifically, Andre, if somebody is told that they are to be, their position is lost and they need to file for unemployment, you file paperwork with the Georgia Department of Labor. The reason for the separation of your employment is listed. If it is through no fault of your own, you should receive unemployment benefits. Employers can tried to dispute whether you would get unemployment benefits if they say you were terminated for cause. So, for example, if an employee just doesn't show up for a week and doesn't have an excuse, or if an employee gets into a fight, or if an employee steals or does something else that's not something that's beyond just not doing a good job, but misconduct, the employer might want to say, no, they've been terminated for cause, and they might be ineligible for unemployment. And then the main obligation, to my understanding, when you are on unemployment is you have to be actively looking for new employment and check in on a periodic basis with the unemployment office and certify that you're in fact looking for new work.
Jefferson, quick question. We're nearing the end, but it just occurred to me, could somebody fire an employee because they have COVID, or would that be illegal?
I believe that would be, I believe under the current statutes, that would be illegal because people are supposed to be provided time off from work, at least but you might not have paid leave, but no, somebody should not be terminated for that reason. I think you'd have to look at the question of, did the employer give them the unpaid leave required by the statutes? And at the end of that unpaid leave time, did the employer decide they were not going to bring them back? I haven't heard of that happening yet. I don't think it's worked its way through the system. And so I don't have a clear answer for that. As a plaintiff's attorney, I would suggest that would be, horrible, and somebody should not do that. I would try to shame that employer. But the question would be whether that is considered a disability under the Americans with Disabilities Act, and I don't know the answer to that. I think that's one of those things that we're going to have to wait and see how it shakes out over the coming months.
Yeah, or some kind of discrimination.
Yeah, and Jefferson, I know business should be booming for lawyers. How has this pandemic impacted your industry?
Yes and no. I think certain attorneys are booming. I think the bankruptcy attorneys are going to be booming. I think a lot of labor and employment attorneys that specialize in this and answering these questions are going to be booming. I think the merger and acquisition lawyers, the deal makers, work is slow for them. I think real estate lawyers, work is slow for them. People who close on houses. I mean, the real estate market hasn't collapsed, but it can't be as strong as it might otherwise be. There have been increasing articles that I've read, and maybe people aren't going to complain about this, but the attorneys that you see advertising on TV that help you if you get into a car wreck and to fight with your insurance company, okay, you see them again and again, and we all know who they are, and they serve a need. But with the past 3 months, particularly in the Atlanta metro area, with the dramatic decrease in driving, there has been a dramatic decrease in car accidents. There has been a dramatic decrease in business for injury attorneys. And so many of them don't have it. In my case, I've stayed busy, but because my clients are individuals and small businesses, it's no good for me to be busy if my clients can't pay me. And I always try to be careful to do the amount of legal work that my clients have the ability to pay for. I have a client that owns 2 pizza restaurants, and we're in the middle of a lawsuit. And I have concerns about whether that client is going to make it through this. I have a client that,
interesting times.
It is.
Very crazy.
But Jefferson, it has been great. We learned a lot by having this discussion, and you cleared up a lot of questions that we all have. But where can our listeners find more information on your practice?
Well, I can be called at any time. The best way to get in touch with us and see about my practice is probably to go to our website, and it's www.ccealaw.com. Stands for Cohen, Cooper, Estep, and Allen. So if I could just leave your listeners with one thought, it's whether you want to hire me or any other attorney, the time to know who your business attorney is before you need one. Just as you don't want to show up at the emergency room with a burst appendix and they say, "Who's your doctor?" and you say, "I don't have a doctor." You don't want to go looking for a lawyer when the sheriff is knocking at your door, serving you with a summons. The best time to get a business lawyer is before you need one.
Well said, Jefferson. Well said.
Absolutely. Yep.
Thanks so much again for stopping by. We thoroughly enjoyed the conversation and hope to have you again in the future.
I enjoyed it as well. And thank you both. Hope your businesses continue to do well.
Definitely. And to our audience, we really appreciate you joining us for another episode. Please remember to listen to our new episodes on your favorite podcast platforms weekly. And further, visit our website at yourcompanyhealth.com and like our Facebook page. And also subscribe to our YouTube channel at Your Company Health. And until next time, stay safe.
Stay safe, everyone. Bye.